major decision from the Supreme Court that could have larger implications on gun laws nationwide.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
This case could reshape how far states can restrict your right to carry and where.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Government may not regulate individuals' possessions of weapons for self-defense.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
The government just made a move that could completely eliminate gun permit requirements across America. And if you live in one of the 8 states where you need permission just to buy a handgun, your entire world is about to change. Right now, the Supreme Court is preparing to hear a case that targets something affecting millions of Americans who don't even realize they're being denied their constitutional rights. The Department of Justice has taken an unprecedented stance, arguing that forcing citizens to get permits before purchasing firearms violates the Second Amendment entirely. This isn't just another gun case. This is the case that could fundamentally transform how constitutional rights work in America. In 8 states right now, you cannot legally purchase a handgun without first begging the government for permission. Massachusetts, New Jersey, New York, Connecticut, Hawaii, Illinois, Maryland, and Washington, D.C. all require citizens to navigate a maze of applications, fees, fingerprinting, and waiting periods that can stretch for months. In Illinois alone, over 2.4 million people hold firearm owner identification cards, which they must possess just to own any gun whatsoever. The financial burden these states impose is crushing. Between application fees, mandatory fingerprinting, required training courses, and photograph requirements, citizens routinely spend between $200 and $500 before they can even enter a gun store. And here's the kicker. After spending all that money and time, the government can simply deny your application without giving you any meaningful explanation. But the real story behind these permit systems is far darker than most people realize. New York's Sullivan Act, which still forms the foundation of their permit system today, was passed in 1911 by a corrupt Tammany Hall politician named Timothy Sullivan. He didn't hide his intentions. The law was specifically designed to disarm Italian and Irish immigrants who he openly called dangerous criminals. This wasn't about public safety. It was about keeping guns out of the hands of people the government deemed undesirable. The racism didn't stop there. Between 1910 and 1965, Southern states implemented permit-to-purchase laws during the Jim Crow era with explicitly racist intentions. A 1941 study of North Carolina's permit system revealed the shocking truth. White applicants were approved 84% of the time, while black applicants with identical qualifications were approved just 24% of the time. The system was designed from the beginning to deny constitutional rights based on race. Today, while the explicit racism has been removed from the text of these laws, the underlying power structure remains unchanged. Government officials still wield broad discretion over who gets to exercise their rights. Processing times still create insurmountable barriers for people who need protection immediately, and low-income communities continue to bear the heaviest burden of these discriminatory systems. The Supreme Court already addressed this issue in a landmark 2022 decision that should have changed everything but didn't. In New York State Rifle and Pistol Association versus Bruen, Justice Clarence Thomas wrote for the majority that the Second Amendment protects a fundamental right, not a government-granted privilege. The court established that any gun regulation must be consistent with America's historical tradition of firearms regulation from the founding era. The Bruen decision explicitly rejected the legal framework that lower courts had been using to rubber stamp virtually every gun control law. Instead, the court demanded actual historical evidence from the founding period showing that similar regulations existed and were accepted. This should have been the death knell for permit systems that didn't exist until the 20th century. But here's where things get interesting. Instead of complying with the Supreme Court's clear directive, anti-gun states essentially gave the court the middle finger. New York passed the Concealed Carry Improvement Act within weeks of the Bruen decision, creating an entirely new web of restrictions. They designated so many sensitive places where guns were banned that carrying a firearm legally became virtually impossible. This defiance raises a fundamental question about the rule of law in America. If states can simply ignore Supreme Court decisions they disagree with, then constitutional rights become meaningless words on paper. The Constitution either limits government power or it doesn't. There's no middle ground. What most people don't realize is the staggering amount of money flowing through these permit systems. This isn't just about constitutional principles, it's about a revenue stream that states have become addicted to and will fight tooth and nail to preserve. Take Illinois as an example. Their firearm owner identification card costs $10 and requires renewal every 10 years. With 2.4 million active cards, the state collects roughly $24 million per decade just from basic applications and renewals. Add in their concealed carry licenses at $150 each, with over 360,000 holders, and you're looking at serious money. New Jersey's system is even more lucrative. They charge $50 for a permit to purchase a handgun, but here's the catch. Each permit only allows you to buy one handgun and expires after 90 days. Want to buy 2 handguns? That's $100. 3 handguns? $150. The state extracts well over $100 million annually from citizens trying to exercise their constitutional rights. Maryland takes the financial exploitation to another level. Their handgun qualification license requires completing a 4-hour safety training course costing between $75 and $150, submitting fingerprints through approved vendors, charging another $50 to $75, paying a $50 application fee to state police, and then waiting up to 90 days for approval. By the time you're done, you've spent hundreds of dollars and months of your life just to be allowed to purchase a firearm. These systems function as modern-day poll taxes on constitutional rights. They ensure that only the wealthy and well-connected can afford to exercise their Second Amendment freedoms while pricing out the very people who often need protection the most. The Department of Justice's recent intervention in this Supreme Court case represents a seismic shift in federal policy. For decades, the DOJ remained largely silent while states trampled on constitutional rights. Not anymore. The Trump administration's DOJ filed an amicus brief that doesn't mince words. Permit-to-purchase systems are categorically unconstitutional, period. The DOJ's brief demolishes every historical argument the anti-gun states have tried to make. Their researchers examined the complete historical record from the founding era through 1900, and their findings are devastating to the gun control lobby. Not a single state or territory in American history required ordinary citizens to obtain permits before purchasing common firearms for self-defense. Not one. The brief systematically destroys the bogus historical analogies that anti-gun states desperately cling to. These states love pointing to colonial laws requiring gunpowder storage in public magazines, claiming this shows a tradition of gun regulation. But the DOJ exposes this for the deception it is. Those were fire safety regulations in densely populated areas where a gunpowder explosion could level entire city blocks. They had nothing to do with restricting gun ownership. Here's the bombshell that should be making headlines everywhere. The DOJ explicitly states that permit systems were invented in the early 1900s for the express purpose of racial control and immigrant exclusion. No amount of modern window dressing can cure their unconstitutional origins. A law born from racism cannot be reformed into constitutionality. The battle lines are clearly drawn. 27 states have filed briefs supporting the challenge to permit systems, representing over 175 million Americans who live under constitutional carry or shall issue systems without purchase permits. These aren't just rural states with small populations. They include Florida with 22 million residents, Texas with 30 million, and Ohio with nearly 12 million. These states make a powerful empirical argument that destroys the public safety justification for permit systems. If permits were actually necessary for safety, states without them should have significantly higher rates of gun violence. But the data shows the exact opposite. Alaska has constitutional carry with 0 permit requirements, yet their rate of gun homicides by legal gun owners is lower than New Jersey's, despite New Jersey having some of the strictest permit requirements in the nation. On the other side, 21 jurisdictions defend permit requirements, revealing a fundamental disagreement about what constitutional rights mean. Their argument boils down to this: even though the Second Amendment exists, the government can still force citizens to prove they deserve to exercise it through applications, fees, training, and waiting periods. The Supreme Court's composition suggests a favorable outcome for gun rights, but nothing is guaranteed. Justice Clarence Thomas, who authored the Bruen decision, is the court's strongest Second Amendment advocate. His previous opinions show 0 tolerance for governmental infringement on constitutional rights. Justice Samuel Alito consistently votes to strike down gun restrictions and has shown particular impatience with lower courts that try to evade Supreme Court precedents. Justice Neil Gorsuch takes the Second Amendment's text seriously, particularly the phrase, "shall not be infringed." He joined Thomas's Bruen opinion without reservation. Justice Brett Kavanaugh, while slightly more moderate, remains solidly pro-Second Amendment. Justice Amy Coney Barrett wrote powerful dissents supporting gun rights on the appellate court, though she remains somewhat unpredictable on the Supreme Court. Chief Justice Roberts presents the biggest question mark among the conservative justices. He cares deeply about the court's institutional legitimacy and might seek a narrower ruling to avoid state defiance. The three liberal justices will almost certainly vote to uphold permit systems, but even if Roberts joins them, there are still 5 solid votes for protecting Second Amendment rights. If the Supreme Court strikes down permit requirements, the immediate impact would transform gun rights for over 150 million Americans. Citizens in Massachusetts would no longer wait months for government permission to buy their first handgun. New Jersey residents wouldn't need to pay the state for the privilege of exercising constitutional rights. The entire bureaucratic apparatus of control would crumble overnight, but the ripple effects could extend far beyond purchase permits. If requiring permits before exercising Second Amendment rights is unconstitutional, that logic naturally extends to concealed carry licenses. States could still require licenses for public carry, but they would have to be shall issue, meaning any law-abiding citizen who applies must receive approval without arbitrary discretion. The financial implications would devastate state budgets dependent on permit fees. Billions in revenue would evaporate. The mandatory firearms training industry in permit states would collapse, though voluntary training would likely increase as responsible gun owners seek education without government coercion. Anti-gun states won't go down without a fight. New York's response to Bruen showed us their playbook. When one restriction falls, immediately create 10 new ones. The real question becomes how many times the Supreme Court must slap down these states before they finally respect constitutional rights. This case transcends gun rights. It asks whether constitutional rights are inherent limitations on government power or merely privileges that politicians can regulate into non-existence. If the government can require permits before you purchase a gun, what stops them from requiring permits before you attend church? If the state can make you wait 90 days and pay $300 before exercising Second Amendment rights, can they do the same before you exercise Fourth Amendment protections against searches? Every day these permit systems remain in effect, law-abiding citizens who need firearms for self-defense are forced to wait while bureaucrats shuffle paperwork. These aren't abstract legal questions. They're life and death realities for Americans whose constitutional rights face daily violation. This Supreme Court decision could restore fundamental rights for millions of Americans currently living under oppressive permit regimes. The justices hold the power to affirm that rights enumerated in the Constitution cannot be treated as second-class privileges subject to government whim. That's it for today, folks. See you in the next video.